So I'm going to turn now to constitutional law and hopefully give you a better sense of what I'm talking about with the program, how it's structured, and because I generally go through the same sort of structure every class period. Maybe that can get a little bit monotonous, but it can also be predictable, and hopefully people then can follow along well. So the constitutional law course, it's my favorite in the program. I'm a constitutional law person. That's where I write. That's where I do most of my reading. And constitutional law is generally divided into two subjects. In Dayton, we actually have a separate course for each one of these, two separate 3-credit courses. We have it condensed into one in this program. And we're still looking at two big topics: the structure of the government, governmental powers, and then individual rights. And so as we go through the course, I like to start with, where are we in the course, right? Where are we in the structure? How does this tie into the bigger picture? And I thought I would start us here pretty much at the beginning. So when I start the constitutional law course, which is going to be offered in the summer, I will give a big lecture on constitutional interpretation and constitutional history to start us off. I'm not going to do that today because that would take all of our time, and I don't think that's going to be as helpful. But after that, I go to the topic of judicial power and judicial review. It's really our first substantive topic in the course, and so I thought we could start there. Given what's going on in the United States lately, I think it's a hugely relevant issue, a very important issue, and something that I find fascinating, something that is a little still unsettled today, perhaps. What is the role of the federal courts? Now, the federal courts have a number of jobs. They perform a number of important functions, but what I'm getting at here is the core responsibility of the federal courts in enforcing the constitutional system. So again, this is the very first building block of the course in constitutional law. What is the core power of the judiciary? And the background here, if you look at constitutional history, at the founding, there was a big debate. Are the courts really going to help protect liberty and the constitutional structure, or are they more likely to be the threat to liberty? Right? At the time of the founding, we had just fought a revolution against a monarchy, and most people were worried about the executive, right? They're worried that we could have a president take over and try to become a new king. People like Alexander Hamilton, a pretty famous founder who has a musical now, I guess, he called the judiciary the least dangerous branch because it doesn't have the power of the purse or the sword, right? It doesn't have the power to fund anything. It doesn't have the power to enforce a judgment. All it can do is decide and issue an order. The rest of the government then has to decide to enforce it, to follow up on it, for it to mean anything. So Hamilton said the judiciary is not a threat to liberty at all, right? The judiciary is, in fact, the least dangerous branch. The response from the anti-federalists, the people who were against the Constitution, they used pseudonyms. They didn't use their real names. Brutus was the name this guy went by. He called the judiciary the greatest threat to liberty. And that was because he envisioned a modern view of judicial review, where the Supreme Court, 9 unelected people, can run the entire country in a sense. They can overrule the decisions of Congress, the people's representatives, and the president, the only person who's elected by the entire American people. And again, these 9 individuals are unelected. They're not representative. They're elites. And so Brutus thought, this is dangerous. This is dangerous. We're elevating them. This could be a new aristocracy where they're in control of everything. And that is a key question I'm always pointing students back to throughout the semester. Who is right here? Who is right? Is the court something that is facilitating the system, or is it instead the biggest threat to liberty? And the first building block here, perhaps the most famous case in all of constitutional law, is Marbury versus Madison. If you've heard of one Supreme Court case, there's a fair chance it's Marbury versus Madison. And it's not important for the actual result, narrow result in the case. this is one of those cases that is famous for the principles behind it and the underlying reasoning. So the case itself is pretty obscure. President Adams, this obviously an old case, 1803. President Adams here appoints Marbury as a judge after President loses the election. So there's a very contentious election between Thomas Jefferson and John Adams in 1800. They kind of hate each other at this point in time, and Jefferson wins. Jefferson wins, and as Adams is losing, he's appointing a bunch of judges to the bench to try to, have his party hold on to some power. Jefferson is not happy about that, so he refuses to cooperate. And John Adams doesn't get everything done that is necessary before he leaves office. And so for Marbury to get his commission and officially be appointed as a judge, he needs Jefferson to sign some paperwork. But Jefferson refuses to do it. And James Madison is his Secretary of State. He's the officer responsible. So we have this lawsuit, and the court looks at, well, is he entitled to this commission? And the court says that Marbury, the justice of the peace here, he is entitled to the commission. He should be a judge. He's already been appointed by John Adams. All that is left is some paperwork, right? The commission has already been signed. It really just needs to be delivered to Marbury. There's nothing much more to be done. Thomas Jefferson is just holding this up on his own. So the court says, Jefferson, you're acting illegally, but they then dismiss the case. They dismiss the case and they do not order Jefferson to do anything. The key here is why? Because they say the law that gave them jurisdiction in the case is unconstitutional. So they say, let me actually jump down to this slide here. This is the big thing. They announce judicial review. And in judicial review, the idea is that if there is a statute, a law passed by Congress that violates the Constitution, then it is void. It is has no force. It is a nullity, and the courts therefore cannot enforce it. And it really just flows from this hierarchy of law, right? At the bottom, we have state law, a statute passed by the state or created by the state courts. That is law, and it is binding. But if there is a conflict between state law and federal law wins. We know that because there's a provision in the Constitution that says so, the Supremacy Clause. But it's also, the idea is, that's our national law. It is created by the people of America, whereas state law is created by the people of Ohio or the people of New York. So federal law is supreme. And if there's ever a conflict between a federal statute or treaty and the federal Constitution, then the Constitution must win, because the Constitution comes from the highest authority of all, the sovereign people of the United States, right? That's the whole idea of American democracy, is that political power resides with the people, not with the president, not with Congress, not with the courts. No, political power rests with the people, and constitutions are ratified directly by the people. That's what makes them different, right? We elect a president, we elect a Congress, but we actually vote as a people to ratify the text of the Constitution. So that means something more. It comes directly from the people rather than their representatives. Therefore, the court must declare a statute unconstitutional if the court thinks it violates their understanding of the text. That sounds intuitive, perhaps. It does to most of my US students anyway. But when we look at their argument, it gets a little bit shakier. So here's the argument that John Marshall makes, the Chief Justice. He says that judicial review is implicit in judicial power. Now, the funny thing about this is there is not a single thing in the Constitution that says courts can exercise judicial review. The Constitution lists a lot of powers. It's a very short document. This is it right here, Pocket Constitution. It's a very short document. And for For the federal courts, Article 3, it simply says they can hear cases and controversies of various types. It never says, federal courts, you can strike down an act of Congress if you think it's invalid. It never says that. So where does that power come from? Well, the court says, this is the story. When deciding cases, judges need to figure out what the law is. That's what a judge does, right? The judge has to determine when there's a conflict, there's a plaintiff, there's a defendant, well, what is the law that's going to govern the dispute? And then we go back to my pyramid. Well, in trying to figure out what the law is, the Constitution trumps a statute. It's of higher authority. And so when deciding a case in the context of a case, the court must declare a statute to be unconstitutional if it conflicts with the Constitution and refuse to enforce it. Notice that there's nothing unique about this for the courts. It's the court saying, as a court, we must find what the law is. And as a court, we can determine the rule that is going to apply to the parties in this case. That's sort of the textual justification or the constitutional justification being, even though the Constitution doesn't say we can do this, it's implied in the ability to judge a case. The court also says judicial review is a good thing, right? We need judicial review because without judicial review, the Constitution is meaningless, right? Why have a written Constitution if you're not going to have judicial review? Going back a second here, England did not have courts with judicial review. There was no court in England telling the king what he could and couldn't do, right? That just didn't make sense, though, because the sovereign was the king. Political power rested with the king, and so no court can tell the king what to do. In America, it's different. The political actors, Congress and the president, are not sovereign. The people are. And so the idea then is that the people have given the federal courts the authority to play umpire, to ensure that everyone follows the Constitution and, enforce the rules of the game. It's unique. It has a special place. That's sort of the idea we get from Marbury versus Madison. Justice Marshall talks about how without judicial review, there's nothing to make the Constitution stick. There's nothing to limit the power of Congress and the president. Congress and the president could just pass laws that are clearly unconstitutional, and there wouldn't be anything we could do, right? For the Constitution to mean anything, we need to have enforcement from the courts. That's his argument. I'm going to come back and question that in a minute. That's a big part of what we do in con law in the U.S. is we give the arguments that the courts make, but then we question how valid they are, how far we can take them. But before I do that, I want to give you the full story. So the next case in this series, which if we were taking the course, I would be spending more time on these, especially this one. This is a really important case, but it doesn't give us a huge amount of the story that I'm trying to tell today. So Martin versus Hunter's Lessee, another really old case, early 1800s, it says that the federal courts can hear appeals from the state court system on issues of federal law. And it's just an important building block. So Marbury versus Madison says courts can declare a law unconstitutional. Martin versus Hunter's Lessee is necessary, because it tells us that if a state court decides something, that can be appealed up to the federal Supreme Court, meaning that we can enforce the Constitution, right? The state courts can't block that enforcement. They can't fracture the meaning of the Constitution. We're worried that without the ability to get every case involving federal law up to the same court, the Supreme Court, well, then if we can't do that, we're not going to have uniform federal law throughout the country. And honestly, one of the reasons we have the Constitution was a desire for uniform federal law. This is the one I wanted to get to. So the next case in the series that I teach in this unit is Cooper versus Aaron. And Cooper versus Aaron gives us what is the issue with modern relevance today: judicial supremacy. So in Cooper v. Aaron, the court gives us this statement that has been known as judicial supremacy. And the idea is when the court issues a decision, its ruling is binding on everyone, even people who are not parties to the case. Even people who are not parties to the case. So what am I talking about? What does this mean? Well, I think it's easier to illustrate when we get into the case a little bit. So the case here, Cooper v. Aaron, involves segregation. So in Brown v. Board of Education, a big case we talk about in the class, the Supreme Court held that racial segregation is unconstitutional in public schools. So it's 1954. And no, yes, I will be teaching some U.S. history in this course. It's just necessary to understand the course. So we have segregation in the late 1800s, early 1900s to mid 1900s. And the southern states are refusing to integrate, right? They're fighting segregation. I'm sorry, they're fighting integration, fighting for segregation. So we have the Supreme Court declaring that segregation is unconstitutional because it violates equality in 1954. But the southern states are not enforcing that at all. The southern states are, when I say southern, it varies locality and state, but the core deep south is integrating no one. And in this case, we're looking at Arkansas. And in Arkansas, the local government had tried to integrate the Little Rock public schools. They had tried to send some Black school children into the white public school. The governor of Arkansas prohibited it. He, in fact, stations troops outside of the schoolhouse. He is preventing the authorities, the local school board, from complying with the federal court orders. And the President Eisenhower sends in troops and refuses to let the governor block integration. And essentially what's going on here is that the state of Arkansas is rejecting the Supreme Court's interpretation of the Constitution, right? Supreme Court said segregation is unconstitutional and wrong. It violates equal protection. The state disagreed and tried to say the Supreme Court's ruling is not binding on us because we were not a party to Brown v. Board of Education. And the court in Cooper v. Aaron says, no, Arkansas, you are bound by the Supreme Court's interpretation of the Constitution the second it is rendered. That is the idea behind judicial supremacy. So again, the idea with judicial review is that in the context of a case between a plaintiff and a defendant, the court needs to decide what the law is. And so if a law is unconstitutional, it will have no force. That's all within the context of one case. If we move beyond to Cooper v. Aaron and judicial supremacy, there the court is saying, if we declare a law as unconstitutional in a case, that means it's null and void throughout the entire country and can't be enforced with respect to anyone. That's a much bigger claim, right? That's a much, much stronger power. The power of judicial review that we see in the 1800s in Marbury versus Madison is much more narrow. It's going to make it harder for the federal government to enforce or the states to enforce a law that is unconstitutional, but it's not going to be an absolute barrier in the way that judicial supremacy is. So judicial supremacy makes the court front and center. It makes the court far more powerful than it was early on in U.S. history. And I think that's just a fact. The Supreme Court has assumed a very prominent role in our system. Whether or not it's supported by U.S. history, it is simply true that the Supreme Court is the final expositor of our Constitution. It tells us the final meaning of the Constitution. And the expectation then is that the rest of the country is going to fall in behind and support that interpretation of the Constitution. So, or at least obey it. And the argument they make is what I have on the screen here, that Article 6, the Supremacy Clause, says the Constitution is the supreme law of the land. Constitution and federal law is supreme. Then the court says the federal judiciary is supreme in its exposition of the Constitution. Therefore, all government officials must follow the court's interpretation. Notice, I mean, at least to me, that's not much of an argument, because the entire argument is their assumption, number two. Number two is, in this argument they make, is kind of the conclusion. When you assume your own conclusion, it's not the strongest argument in the world. And so at the end of the day, I think the best argument for this approach, this understanding of court power, is policy. The idea that we need consistent, strong governmental action. So we need one voice to decide the meaning of the Constitution and which statutes are enforceable. And it's better to be the court than the president. Better to be the court than Congress, because the court has superior expertise and judgment respecting the law and the Constitution. And a lot of people accept that and agree with that, right? The Constitution, that's a legal document. Courts interpret it, courts apply it, courts should enforce it. The court should run the legal system. And I'll leave it. I have a couple. So before I get there, right? So that's our normal story that we tell in law school, that the courts start out somewhat limited in power. They're not seen by most people as a huge threat. They slowly assert the power of judicial review, which morphs into this ability to tell the whole country what the Constitution means. But the federal courts have never really, it's never been accepted that they have that power by the entire system. It's just sort of been assumed. And if we look at the modern era, you can see the present administration pushing back against what the courts do sometimes. Never explicitly, the Trump administration has never said, hey, we're not going to follow the courts. We ignore the courts don't matter to us. They've never said that. But you can see them pushing back a little bit on the power of the court to order the president around, to tell the president what position the president must take, to order the president to take a specific action. And a big part of that comes from the basis of judicial review, right? Once you understand where judicial review comes from, how we got it, you can understand why the courts are having a hard time with these issues around executive power. The courts do not see themselves as in charge of the executive branch. They're not. They're supposed to be an independent, co-equal branch of government. And so the idea that the judiciary is going to be telling the president what to do on a discretionary act, or Congress or anything like that raises issues. That's difficult. The court's power comes from the structure of the government, and really U.S. history, this slow acknowledgement that it's better if the court decides than someone else. And as we get this pushback, we're going to see these other arguments, get pushed to the fore. And in particular, I would just leave you with this. Why does it have to be the Supreme Court, right? If we go back to this argument here, I'm not sure. In fact, I know not every country agrees with this, right? Look at a country like England, the country that we splintered off from. They don't have a Supreme Court that tells Parliament what it can do and what it can't do, right? Parliament decides what the Magna Carta means. Parliament is the decider of the British Constitution. We could have a government like that, right? We could have a government where Congress is bound by the Constitution, but there's no court that can strike down their laws. And the argument for that would be something around the idea, and there's historical support for this. People like Abraham Lincoln would say things like this, that, well, the president and Congress swear an oath to the Constitution. They have just as much of a right to interpret it as the court. And so these arguments still get kicked around. You can see them in the discourse around how to constrain Trump. But you know, the traditional response has always been, in our system, it's always been the court. You know, we struggled with this idea early on, and in Marbury versus Madison decided leaving the power to interpret the Constitution to Congress or the president is too dangerous. Because if Congress gets to interpret the Constitution is nothing other than a piece of paper. They can overrule it at their will. And if the president gets to interpret the Constitution, well, then we have a king, and we're back to where we started with England. And so that's the American history and tradition has always been that the power flows to the courts. It's just taken a couple hundred years to really get there, and we can see some pushing around the lines on that. But I've been talking for quite a while. I think I've fit my allotted time. I think that's we're starting to get a little abstract. I could go into a lot more detail here, but that probably makes sense to end it right there. In the course, we would spend more time on this, and I always try to make sure we all understand what the rule is the way it is now before I sort of question and get at the complexity and potential issues that are out there, because I do understand you want to get the rule. I do think with this one, though, it's an interesting issue, and I love to try to tie it back to current events, which in the last couple of years has been very easy to do. So thanks for hearing me out, and look forward to your questions.